Hello Live Law viewers, welcome to Courts Today by Live Law, your daily roundup of legal updates from across the country. I'm your host Urvashi Chauhan, here to keep you informed and up to date. Let us start with the headlines before diving into the details. CJI Sanjiv Khanna has denied going back to old system of adjournment letters circulation. The Supreme Court has allowed NIA's plea to transfer 8 criminal cases from the state of Manipur to Assam. In the Sheena Bora murder case, the prime accused, Indrani Mukerjea, has approached the Supreme Court seeking permission to travel abroad. The top court has dismissed pleas to revive bribery and PMLA cases against Ex-MLA KM Shaji. The Madras High Court has allowed installation of Father Stan Swamy's statue in private land of a man. The top court has dismissed a PIL to use paper ballots for voting in India. In the Pennaiyar river dispute, Tamil Nadu and Karnataka governments have informed the Supreme Court that mediation process has failed. The Supreme Court has allowed scribe for a 100% blind law graduate to attend CLAT PG exam. And the Supreme Court has called for tree census and vigil mechanism to prevent illegal tree felling in Taj Trapezium zone. Today is 26th November, a day that celebrates the foundation of our democracy. It is the Constitution Day or the Samvidhan Divas. On this day in 1949, our Constituent Assembly adopted the world's lengthiest written constitution. If you read the preamble carefully, it starts with "We the people of India" and ends with the words "adopted, enacted and given to ourselves this constitution on this 26th day of November 1949. This year in 2024, we are celebrating 75 years of this adoption. Some people get confused about this day and Republic Day on 26th January. 26th January 1950 actually marks the date when the Constitution officially came into force and became applicable as the law of the land. So in 1949, the day Constitution was adopted, some of its provisions were partially enforced, but the rest of the Constitution came into full force on January 26, 1950, when India became a republic. Now, why was 26 January chosen as the date? To know that, you should read about the Purna Swaraj Divas in 1930. Well, today, speaking at the Constitution Day function organized by the Supreme Court Bar Association, Chief Justice of India Sanjiv Khanna made it clear that the old system of seeking adjournments by circulation of letters will not be reinstated. This practice that was followed in the past allowed the lawyers seeking adjournment in the Supreme Court to circulate a letter in advance. This would save the time of the judges who need not read the files and the opposite parties who have to prepare for the matter. This process was stopped by former CJI Justice Chandrachud last year in December. Then in February this year, the court established a procedure for adjournment slips. The procedure allows seeking adjournment only once in a case. And in certain cases, also fresh and regular hearing matters, no adjournment letters are entertained. But after CJI Khanna took over, members of the bar had requested him to allow the previous practice. Today, the CJI has denied going back to the old ways. He highlighted some data in this regard, saying that at one point, there were nearly 1,000 adjournment letters which were circulated on daily basis. However, as per the new system, the numbers have come down to about 150 adjournment letters per month. Therefore, the CJI said that going back to the previous system was counterproductive. The bar members had made another request, that is publication of physical cause lists. This request has been accepted. At the function today, the CJI further spoke about plans to improve the infrastructural facilities for lawyers, such as an additional conference room, extra cabins for oath commissioners, extra photocopy facilities, etc. In his address, the CJI talked about the importance of contribution of lawyers in making the judiciary a robust guardian of the Constitution. He said, "Better the bar, better the judges." The Supreme Court has today transferred 8 criminal cases which are pending before the National Investigation Agency's Special Court in Manipur to Assam. NIA sought the transfer, saying that the situation in the state of Manipur was not conducive for conducting a free and fair trial. This, as you might be aware, is because the state has been in chaos since the violence broke out between the Meitei and Kuki communities last year. Recently, there have been reports of gruesome murders and disappearances which have fueled the tension further. The 8 criminal matters unrelated to each other are under Unlawful Activities Prevention Act. They were earlier transferred from the Manipur police to the NIA for investigation. Today, the advocates appearing for various respondents in this case said that the trial should be transferred to Delhi. Some said that it should be transferred to Mizoram or state of Meghalaya. However, the bench of Justices J.B. Pardiwala and R. Madhavan noted that last year the court had ordered transfer of 27 CBI cases from Manipur to Assam because of the intense situation. So the court today said that the trials would have to be transferred to one state only. When some of the parties expressed that the air travel fare to Assam is very expensive and roads are closed, the court said that it will be NIA's responsibility to ensure the safety. The court also allowed the accused who are on bail to join through video conferencing. Indrani Mukerjea, the prime accused in the high-profile murder case of Sheena Bora, has approached the Supreme Court seeking permission to travel to Spain and the United Kingdom. For 6.5 years, she was in jail as an under trial in this case before the Supreme Court granted her bail in 2022. Now she has approached the top court in an SLP to challenge Bombay High Court's order that denied her permission to travel abroad. Why she wants to travel abroad, she says, is to take care of some pending works which require her presence. These include activating certain bank accounts for which biometrics are necessary, the appointment of a real estate agent, repairs and maintenance of properties, etc. She also mentioned the need to update her will by removing the name of her ex-husband. In her special leave petition, she says that because she has never violated any bail conditions, there is no reason to suspect that she will abscond. Stay tuned with us to know whether the court grants her permission to travel abroad or not. The bribery and money laundering cases against Indian Union Muslim League leader and former MLA K.M. Shaji has now been fully quashed by the top court. The allegation was that he accepted a bribe of 25 lakhs from the manager of Azikode Higher Secondary School, Kannur, for sanctioning a +2 course in 2014-2015. The money laundering case arose out of this bribery case. But the Kerala High Court had earlier dismissed the case initiated by ED for money laundering and the FIR filed by Vigilance and Anti-Corruption Bureau. The High Court had said that no prima facie case was made out. The court also found no evidence of a demand for illegal gratification by Shaji. But State of Kerala and the Enforcement Directorate approached the top court against the High Court's order. A bench of Justice Abhay S. Oak and Justice Augustine George Massey reviewed statements of 54 witnesses recorded during the investigation. It observed that none of the statements indicated that Shaji personally demanded or received money. The top court said that if the case was allowed to continue, then in future any politician could be roped in. Though the petitioners argued that the ongoing investigation should not be interrupted and that the case should proceed to its logical conclusion, but the court was not convinced and dismissed the SLPs. In the next update, the Madras High Court has allowed a man to install a stone pillar with Father Stan Swamy's photo on his private land, honoring the work done by him for the tribal persons. The man, who teaches about sustainable farming and lifestyle practices, said that his mentor was late Father Stan Swamy, and to commemorate his life, he wanted to erect the stone pillar. But he had been interrupted by the authorities, who sent him a notice and objected to his action. The state submitted before the court that the person had not obtained proper permission for unveiling the stone pillar. It was also submitted that the stone tablet related to a person who was related to Naxals and Maoists, and that it would hamper the law and order of the area. But Justice M. Dhanapani said that the issue of erecting a status in a private land was already well settled, and that the state could not interfere with the private life of citizens and his right to erect any statue within the private premises. He also said that Father Stan Swamy had taken a lot of efforts for the welfare of tribal persons. Thus, the order of the Tehsildar was set aside and allowed the petitioner to erect the stone pillar in his private land. The court also cautioned the petitioner to ensure that public is not hindered while erecting the stone pillar. For those of you who do not know, Father Stan Swamy died in July 2021 as an under trial in judicial custody in the Bhima Koregaon case, in which he was accused of having links with Naxalites. And now let me tell you, the Supreme Court has today dismissed a PIL filed by evangelist Dr. K.A. Paul. He appeared in person and sought physical ballot voting in India and directions to the Election Commission to disqualify candidates for at least 5 years if found guilty of distributing money, liquor, etc. during elections. He said that 180 countries of the world have physical ballot voting. He further claimed that money is distributed during elections. Without giving the name, he said that a businessman had given 1,200 crores to all major 6 parties, including Congress and Bharatiya Janata Party, for elections. But the bench of Justices Vikram Nath and P.B. Varale dismissed the PIL, saying that when a political leader wins the elections, EVMs are not blamed as tampered. But when they lose elections, they say that the EVMs are tampered. The electronic voting machine was first introduced in India in the year 1982 as a pilot project, and by the 2009 Lok Sabha elections, they were used nationwide. The process became more refined with introduction of VVPAT systems for increased transparency. You are already aware that this year the Supreme Court gave an important ruling regarding concerns over security and tampering of EVMs. The court had rejected the pleas seeking 100% cross-verification of EVM's data with VVPAT records. It also denied reverting to ballot paper voting. The Apex Court today allowed a 100% blind law student to avail the help of a scribe as appointed by the consortium of NLUs to appear for CLAT PG, which is to take place on 1st December. A bench of Justices Surya Kant and Ujjal Bhuya heard a writ petition filed by 3 petitioners praying for necessary accommodation in legal examinations, including the AIBE and CLAT. One of them is 90% blind, the other 2 are 100% blind. The consortium had submitted that for second petitioner, a scribe could not be from streams like law and humanities because certain subjects like contracts are common and therefore a conflict of interest will take place. So the bench allowed the help of a scribe as a matter of interim relief, provided that the scribe must be an undergraduate and must not be from a law or humanities academic background. The petition claims that respondents have not followed the Rights of Persons with Disabilities Act 2016 and other government rules which require that people with disabilities be given the choice of how to take exams, such as using computers, large print, etc. The petition also points out lack of clear guidelines on eligibility of scribes, the accessibility of exam centers, etc. Advocate Rahul Bajaj, who himself suffers from blindness, appeared for the petitioners and raised the issue regarding lack of access to computers and soft copies of bare acts for AIBE 19. This aspect of the case is pending for hearing and will be taken up by the court on 5th December. Stay tuned. And now let me tell you, the mediation process between the states of Tamil Nadu and Karnataka over the Pennaiyar river water dispute has failed. The river dispute is a long-standing conflict between the states regarding sharing of water from Pennaiyar river, which flows through both the states. The dispute centers on how the river's water should be divided, particularly during times of water scarcity. In such disputes, the states generally try to resolve the matter amicably. And as per Section 4 of the Interstates River Water Disputes Act, when the central government feels that the water dispute cannot be settled by negotiations, it can constitute a tribunal. In this case, after first round of negotiations failed and the centre was going to appoint a tribunal, the state of Karnataka approached the union saying that it would like to re-explore the possibility of settling the dispute with Tamil Nadu, as its newly elected government in May 2023 did not get any opportunity to negotiate. But today, the bench of Justices Rishikesh Roy and S.V.N. Bhatti was informed that this round of negotiation has also failed. The court has now granted 2 weeks' time to the union to produce the negotiation committee's report. And lastly, the Supreme Court has emphasized the need for a tree census and a mechanism to prevent unauthorized tree felling in the environmentally sensitive Taj Trapezium zone. A bench of Justice Abhay S. Oak and Justice Augustine George Massey has issued notice in a plea seeking formation of a separate committee to conduct a thorough investigation of illegal felling of trees in the Trapezium zone. The counsel for the applicant alleged widespread illegal tree felling, including unreported incidents, and called for an independent investigation. Citing a reduction in forest cover by 9% over the last 4 years, he urged the formation of a separate committee to oversee the issue and conduct a thorough inquiry. The court referred to provisions in tree-related laws such as the Tree Authorities Act that mandate free census to maintain an accurate record of existing trees. Additional Solicitor General Aishwarya Bhati informed the court that FIRs had been registered in cases involving illegal tree felling. She noted that some tree felling activities occurred overnight to evade permissions required for construction projects. She also suggested that either the Forest Department or the Central Empowered Committee could undertake the census. The court has also been considering the issue of enhancing the green cover in Delhi and setting up a mechanism to ensure compliance of court orders regarding compensatory efforts while granting tree felling permissions. The court has also taken a stern stance on unauthorized tree felling in Delhi, particularly in the Ridge Forest area, by initiating a contempt case against the chairman of the Delhi Development Authority. For more information on the cases discussed here, please visit our website at www.livelaw.in. Your support means the world to us. So do not forget to like, share and subscribe to our channel. You can support us by clicking the thanks button below our videos or by becoming a member for just 89 rupees per month.